Hey everyone. Hello again. I see some people that were here yesterday for the other class, so hello again. For those of you who don't know me, my name is Marcela Medzi, and I am in business development for a title insurance company called MIT National. We used to be in an office in One Penn Plaza. I mean, the office is still there. We're just working from home, as you guys can see. And it is my pleasure to have you here to get some credits and to talk to Fernando, who is an amazing real estate attorney, speaks a bunch of languages, knows a lot, and is a great contact for you guys to have if you have any questions and that kind of thing. First of all, I want to take some things out of the way. I know everybody that's doing this is very anxious for their certificates. Just know that you don't need certificates to prove that you took this class. As soon as the class is over, I send an email to the Department of State with everyone listed here, and that's how they that's how they know that you are here, unless you guys are being audited or the company you work for needs the certificate, okay? So there's no rush, but if you need for some urgent reason, just let me know. The affidavit will be sent today or tomorrow morning. I'm doing everything by myself outside of, on top of my full-time job that I already have. So please be patient with me. I also wanted to say that the certificates will take at least 2 weeks. Wait for them. So for now, everybody that is in here, I would like everyone to either turn on your camera so I can see that you're here and paying attention, or you can, if you don't want, if you didn't do your makeup or your hair or you're still in your pajamas, it's fine. Just say hello to me on the chat and I'll mark you as present, okay? So again, I want to introduce to you my good friend, amazing attorney, Fernando Koatz from Gleason Koatz. And today we're supposed to have Charles Snyder, a very good friend of mine that is an amazing loan officer from Citibank now, but he had some trouble with his computer. It burned and crashed, so he's not going to be able to join us, but I still am going to type his information on the chat. He's an amazing point of contact too if you have any trouble with your clients getting loans. Okay, Fernando, you go. And
all right,
guys, if you have any questions, you can type on the chat to Fernando and he can answer, or if Fernando, if you prefer, they can just unmute themselves and ask. It's up to you.
Oh, I prefer. Thank you very much, Marcela. Always a pleasure being here. I work with Marcela also. We have a matter now that's pending. Our company is very helpful. They're a great title company. With respect to the questions, what I usually do, my way of handling is that after each slide I finish, I ask if there are any questions, and just give me a little time to read it and go over it. I think this is about an hour class. We're supposed to finish about 3. And I'm going to go pretty quickly here with a broad range of subjects, which all touch upon what's commercial due diligence, whether it's drafting of the contract or environmental, something about zoning, air rights, rent stabilization, rent control, all these things that are important to know with respect to doing your due diligence as a real estate broker and as a lawyer, and anyone else is involved with the deal, whether it's leasing, because I do talk about leases as well, or purchase and sale. So when I get to the end of one slide, I'll see if there's a question, and I hope I can cover all this ground in an intelligent way where you can learn something in about the hour or so we have. So here's the beginning. As you can see, for slide number 1, the overview of the real estate, commercial real estate due diligence. The contract of sale sounds pretty mundane, but that's really where we start with any purchase or sale with respect to a real estate. And that could be co-ops, condos, townhouses, buildings, and the like, or land, industrial, warehouse, and whatnot. And the contract itself is really a roadmap, which is a cliche, but that's what lawyers we say, because what we have, for us as lawyers, when we look at a contract, it's supposed to try as much as possible to take into account what may or may not occur with respect to the deal, or even afterwards, which is a whole nother thing, these representations that are that survive a closing are very important, because once the deal is closed, that should be the end of the entire transaction from soup to nuts. But we want to outline as much as possible in this contract things that can or cannot occur. And one of the important things, we need to know the capacity of the parties. It stands to reason you make sure whether you're a lawyer or a lender, and lenders really are keen to this, or title insurance, that the corporation that's signing or having someone sign on behalf of the corporation has the power to undertake this through a resolution. And it's whether the corporation is an LLC, for example, it's the manager signing off on it, or in a C corporation was the president or vice president, or in a partnership, the partner can go ahead and execute the contract. No small thing. The premises itself needs to be identified, and that involves partly an examination of property, which can be done by the broker, buyer, or seller, but have someone look in there and find out they have the exact what's a description of the property, which is really important outside of co-ops, because they're different. Technically, they're not even real estate. Because as you know, and I'm digressing here, owning a co-op, one owns shares and a proprietary lease that pertain to the apartment that's being purchased or sold. With respect to real estate, we try to have what are called meets and bounds and try to describe the property. And that's what we're mentioning here in terms of identification, what's referred to in this slide. That's usually an exhibit, especially in commercial sales, to the contract itself, to make sure we're all talking about the same property and that it has those parameters. And this is, of course, reviewed intensely by the title insurance company, because they're going to issue insurance based upon what the property is. Its also identification can refer to personal property. That's more referring to restaurants that are purchased or sold, or hotels, or industrial property, which may or may not include machinery and those kind of things. And it needs to be identified, again, in an exhibit. A lot of these things are covered by the main body of the contract, and then you have an exhibit A, B, C, and so forth, which will list something, for example, description of the property, or identifying the personal property. And another part of the commercial contract, which is important, is as is. Now, as is, it comes kind of from the idea of caveat emptor, which is Latin for buyer beware, which was standard real estate law throughout the country, although I'm speaking now specifically in New York, because I'm only licensed in New York. Well, I'm licensed in Washington, D.C., but I really don't do anything down there. In any case, caveat emptor comes from the common law and says buyer beware. When someone says as is, which is important and helps a lot, especially in these commercial deals, it does not absolve the seller of fraudulent misrepresentation or representation. Someone cannot commit fraud by claiming, for example, that for whatever reason, the building is in certain condition and won't collapse, and it's about to collapse. I'm giving an exaggerated example, but that's why it's important, and this is the whole point of this class, is to have due diligence. And that due diligence involves inspection, environmental, and so forth, and the things that are important to have, because that contract will say as is. And I, representing a seller in my capacity, I will always have as-is clauses, because it does take out a lot that could be a problem for my client. If there's a warehouse or a factory building, I don't want to get into nitty-gritty there and have my client as a seller be worried because there's a brick that's missing or something like that, and that it wasn't covered in the contract because it isn't as is. So to turn it around and say as is puts the burden, short of fraud, committing fraud, on the purchaser. And it's a key part of the way contracts of sale are handled. That's the end of the first slide. Let me see if there are any questions here. Sorry to slow this down. Someone says breaking up. I don't know if that means in terms of my sound. I hope you can hear me. If someone can acknowledge that, I'm sorry about that. Anyway, next slide.
We can hear you.
Okay, thank you, Marcela. With respect to this overview that I'm giving now of commercial real estate due diligence, the other part which is important to know, and any lender can speak to this, or a mortgage broker, has to do with the financing. And a lot of these contracts, not all of them, they will have contingent financing. In other words, just as in a residential deal, they will have something with set firm dates that are usually time of the essence in commercial deals that will say if the purchaser cannot obtain X amount of whatever funding it's looking for, then they will be able to withdraw from the deal. Sellers don't always prefer that, but it does happen in these deals. But with a lot of controls, as I said, there's the thing about having the time of the essence. You cannot dilly-dally as a purchaser and delay things or whatever for your own benefit or out of negligence to try to go about obtaining that financing. The contract should have the specify the loan amount, which stands to reason. And the really important thing here is to know about two types of commercial real estate loans. In this context, with respect to due diligence, in contract of sale, the most common is the mortgage, which the bank and the title insurance company, and again, as a lawyer, especially the seller, but it would be the same thing for the purchaser looking at the seller corporation, obtaining the information regarding the corporation to make sure that that entity has the requisite authority and will go about obtaining this commercial mortgage. And the bank will say, we want to make sure you are who you are and you can meet the bona fides. Something that's a little different is the mezzanine loan. That really refers to, it's really like a second mortgage and secured rather than by the property, by the corporate shares, in other words, in a C corporation of shares, or the membership interest in a limited liability company. And these sometimes are used in certain kind of real estate financing and deals, not so much in sales, but I wanted to bring it up so you know about it if you're not aware of it. They're important because they're easy to foreclose. In other words, rather than going against the property, which can take up, well, forget now where the courts are a mess because of the pandemic and the lockdown and the very slow reopening of the courts. In quote unquote normal times before the pandemic, BP, if you will, a foreclosure on a commercial property would take months and months and months, depending what the circumstances were, 6 to 8 months. It depends on the situation. Whereas in a mezzanine loan, it could be a lot quicker because they're not trying to obtain the property directly. The lender, and it's usually hard money lenders are involved with this, though not exclusively. And when I mean hard money lenders, not institutional banks, private entities that make loans, usually on stricter terms, higher interest rates, but less not due diligence, but requiring less than the bank would require. But in order to obtain this mezzanine loan, there's heavy documentation. A lot of it revolves around, and my firm has been involved with this, issuing what's called the opinion letter. It's a non-consolidation opinion or due authority or due diligence, saying as a lawyer, law firm representing the borrower in this case with respect to the mezzanine loan. And these, by the way, these opinions are required also for commercial mortgages, but in the case of mezzanine loan, they want to make sure, because it's structured almost like a Christmas tree with a lot of different branches, or looking at a genealogical tree of a large family, and a lot of interconnection between different entities. They want to make sure that if this entity goes, in other words, I'm sorry, let me correct myself. If an entity, for example, 5, 10 levels above the actual entity or corporation taking out the loan goes bankrupt, the one holding the loan will not be subject to that consolidation. It's called cram down in bankruptcy. I know I'm talking in a lot of jargon. I apologize, and I'm going quickly, but it's just so you know it's another part of commercial real estate, mezzanine loans. Okay, let me see. Questions? What is a typical discovery period, and does it normally before or after signing contract? That's a good question. I think you're referring to the attendee to due diligence. In commercial deals, a lot of times due diligence is done before the contract, but if it's not, and that due diligence is usually a few weeks, I'm not sure, it depends on the situation and how much leverage either party has, but you can bake into the contract the actual due diligence as long as it's time of the essence, especially from the seller's point of view, that there's no abuse and it goes on forever. And they'll allow a few weeks either for the actual doing due diligence on the plant itself, the building plant or the way it's put together, as well as the environmental. And they'll say, okay, that will be actually a contingency, but you have to do it as quickly as possible. Question, if a contract is as is, can the buyer walk away out of a contract without breach of contract? There are building violations on the property. No, not generally. Building violations, and I'm not sure which ones you're talking about, generally can be cured on or before the closing, especially if it's a monetary fine. But again, that depends on the situation. Can they copy the presentation? Oh yes, I forgot to say this, that I can send you a copy of this PowerPoint. If you send me an email, please, you'll see my address at the end. I'd rather do it that way. It's a lot easier for me anyway. Next slide. Again, continue with respect to this overview of commercial real estate due diligence. An important part of it is the seller's representations. And again, this has to do with requisite authority. That goes back to what I said before about the corporation, the entity, the capacity of the parties. And again, it goes back to what the lender will require, as well as the title insurance, to show that the person or entity that is purchasing and signing on behalf is authorized to do that. And again, a corporation will require some kind of shareholder or board of directors resolution to show that this sale has been approved or purchased. And with the unanimous, with the limited liability company, it'll be what's called unanimous written consent of the manager and members. There will be representation with respect to permits that are applied to the property. That's common in these kind of contracts. Financial statements, very important in rent roll. If someone's buying a multi-family, multi-use building which produces income, it's key to what's going on. Later on, I'll talk a little about rent stabilize and rent control. And the important thing here is in a rent roll, whether it's commercial or residential, is to show and prove and represent, because the representation, if it's not true, can be the subject of a claim by the seller or the purchaser. Then they want that kind of a surety or certainty that they will get the income. Now, it's important here to have also some kind of CPA and some kind of person doing financial analysis with respect to this. I don't do that kind of thing, which goes to another point that I'd like to make, is that any commercial real estate deal, I am operating, especially from the buyer side, but as well as the seller side, with a team. And the team includes the real estate broker, the mortgage broker if there's a loan, the title insurance person, the insurance person, that's another big part of these deals, the environmental engineer for the due diligence, and so forth. Another representation is that it's defect-free as much as possible. That can be done, and that depends on these circumstances, or can be represented on behalf or by the seller concerning the physical plant of the building or the structure. There are other provisions which are common in these contracts, notice provisions, who needs to be notified. I was involved with a deal, which is kind of weird, that they wanted notices not just with the lawyers and the officers of each corporation, but all the different owners. Now, these were smaller entities, but they insisted on it and was agreed upon to have. Another provision which is common is termination provision, keys, who gets them. FIRPTA. FIRPTA is a little off topic here in the sense that that could be part of another class. It's Foreign Investment Real Property Tax Act. And what it refers to is that the seller is not a non-resident non-resident alien of this country. And again, the alien can be a company or a person. And the important thing is and this applies a lot more in residential, when a person is selling property and they're a foreigner, the purchaser is obligated by the IRS under law to retain 15% of the purchase price to pay over as a capital gain tax, 15% for 1 million or more. It was 10% up until a year or so ago. They increased it to 15 for that 1 million or more. And if the purchaser fails to do that, they're going to be in trouble. And I've seen that's happened with lawyers who failed to take care of what they needed to do at a closing. Another miscellaneous provision, and I'm really racing here, I apologize, this is the entire agreement, and if there are heirs involved or any successor or signs or entity, they'll be bound by the contract. And most importantly for real estate brokers, that the only brokers mentioned here are you guys who are involved in this deal. You don't want someone else making a claim down the road and creating a, did I jump? I'm sorry. And creating a litigation. Sorry. Any other questions here? Okay, I don't see any. I just see email addresses. But email me, please. I think if I wasn't clear, after the class, and I will get back to you on the PowerPoint probably within a day or two. Okay, next slide, number 4, talks about the responsibilities for a seller's attorney on a commercial deal. Prepare the contract. Yes, we do that. And as you know, these contracts can be 20, 40, 50 pages long, not including exhibits and so forth. We prepare the closing documents, which includes the deeds and transfer tax returns, although in my case, I certainly rely on intelligent title insurance people to actually prepare the ACRIS form to be filed, and then that's taken care of closing. Any assignment of satisfaction of mortgage, that's a big thing, especially a CMA, consolidation extension of a mortgage agreement, in which an existing mortgage is partially continued or carried over to the new purchaser, and there they can avoid the mortgage recording tax, which in New York can be quite steep to some extent. In other words, if there's an existing mortgage for $2 million and they're trying to get a new mortgage for $10 million, the good thing is to carry over the $2 million with, of course, the approval of the existing lender to transfer it. And then the real estate recording tax, instead of being for $10 million on a mortgage, in the example I'm giving, I'm making up, it would only be $8 million because the $2 million one has been transferred. It's a legal fiction, but it applies and it works quite well. Another thing the seller's attorney is responsible for are title issues. Those are galore. Hopefully we can reach some of those issues at the end of this class. I think I'm already running short on time. And things like meter readings, adjustments, instructions regarding payments. Pretty mundane, but that's the seller's attorney's responsibility. On the other side, the buyer's lawyer, they order the title insurance. They generally do. It rarely happens where the seller has control over that. They order the survey, which is key to any lender, and they clear, which the survey is the map, if you will, of the property, and they clear loan documentation. Any commercial deal, I've been involved with this as a purchaser / borrower. I have to read that document. A lot of things come up that I have to take care of, or at least advise my client to take care of, which could be building violations and so forth, and making sure we have the corporate authority, which is going to be on any loan request or loan commitment, determine the amounts owed, send notices to tenants in the existing structure who are not going to building, who are not going to be kicked out, but should know who the new owner is, and do the final inspection, such as it is. Let me see. I'm having trouble getting up to the, oh my goodness. What am I doing here? Oh, the chat I'm looking for, sorry. Any more questions? I'm finished with this slide. Fernando, no rush. If it goes over a few minutes, is fine. Muito obrigado. Okay. Next question. Sorry, is this one? The next slide is 5. Commercial versus residential contracts. I think that bears repeating.
I don't see your screen anymore.
Did I lose it? I'm sorry. I'm fumbling with this thing, and I'm okay.
You're good.
Okay, I don't know what happened. I apologize. Slide number 5. Thank you. With respect to commercial versus residential contracts, commercial contracts have more actors involved, more parties, and it's really in the nature of the properties involved. I have this kind of wacky, crazy deal representing a seller of a property in Astoria, and it's, I say crazy, wacky deal, none of it disrespect, but my client is the corporation that's selling the property, and the corporation is owned by 2 older children of the first marriage of the decedent who owned the corporation, who died a number of years ago. I didn't take care of the estate. And it's controlled 60% by a second wife who has 3 kids who are not 21 years old. And they are all involved with this deal together with bankruptcy lawyers, because the 2 elder ones are in bankruptcy. This is a taxi medallion place, and they were unfortunately caught and really hurt by the decline in the value of taxi licenses. But the point here is that there could be a lot of people besides, in addition to the lender and the title insurance person and whatnot. Other things, a big difference between commercial and residential, the tenant issues really has to do with assignment and assumption of leases. That's a whole nother subcategory. It goes into the negotiation on the commercial purchase as opposed to a residential purchase, because generally you don't have in a residential a tenant, or if you do, you have one tenant who's been there for whatever reason, a condo. I want to make sure that everything, and the important thing here is that the new owner and the existing tenant recognize and respect one another and maintain the relationship. In other words, a landlord-tenant relationship. The tenant can't claim they can get out of the lease if they wanted to because of the new owner. The new owner can't say that they can kick out someone right away just because they're assuming a lease. They have to respect those rights. And these are other documents that are negotiated as part of the commercial real estate deal. Other issues that come up in commercial, and I mentioned some of these, the financing could be especially different with respect to mezzanine loans. Title contingencies, much more important, and much more, you see it much more in the kind of commercial deals that one is dealing with, as opposed to these residential. And I'm not saying they're simpler per se, because selling a house can have its complications, or a condo or a townhouse, but it's not exactly the same thing. It's not less complicated, but it's certainly a different kind of deal. And then the last thing that I mentioned here on the slide has to do with permitted exceptions. These are important, especially with these commercial deals with respect to easements and zoning and what's allowed or not allowed. I was involved with a deal recently where the purchase price is one thing, and then if they have upzoning, it's called. In other words, they were able to allow an increase in the air rights so they can build a larger building after they tear down the structure they're trying to buy, which is commercial. They want to put apartment buildings, and apartments at market rate to be rented at market rate. In a new building, they want to be able to increase the air rights. They're not sure they can. So part of the deal is that it's almost as if it were a contingency that later on, if it's approved by the Department of Buildings, there'll be an increase in the purchase price. In other words, more money kicked into the deal, even if it's a year or two later. So it makes it more complicated, but certainly much more interesting. I don't see any other questions. Okay. Zoning. So here we go to the thing I've mentioned before. Zoning is part of commercial real estate due diligence, and some of it applies to residential as well. And this could be an entire class, and I've done classes on zoning. The important thing about zoning is to know, and I'm giving you a very broad brush stroke of what zoning is. It goes back to 1916. It arose here in New York City, or New York State, the first in the nation with zoning, because of the equitable building that was constructed in 1912 in downtown Manhattan, and had the unfortunate effect of creating shadows and blocking sunlight for a lot of neighboring property, both residential and commercial, and that led to an uproar that they passed these laws that would restrict and control what could be built depending on where it is. It created districts, manufacturing, commercial, and residential. And for New York, and in New York, I think 70%, I forgot, 75% of the districts are residential, although they can have some commercial aspects to it, and some commercial and some manufacturing can have residential. It's a very, very complicated area of the law. It's very fascinating, but it comes in a lot with respect to some of these deals in commercial properties when someone is buying something and they want to turn it around and do something different down the road by tearing it down or rehabbing it or whatever the purchaser is buying, and they need to get their ducks in a row and understand what is going on with zoning. In 1961, they updated the codes and included air rights that were they're allowed to be transferred as of right, air rights. And the air rights, by the way, again, is the space above the building. Suppose it could be used to build further a higher structure. Not all districts will allow that. And within each district, there are a lot of subdivisions, this R1 to R10 in residential, and the same thing with commercial. And manufacturing is a little different. So if there's a property is aligned one next to the other, 10 linear feet, then as of right, they can transfer those air rights, and it's done through what's called a Zelda Zoning Land Development Agreement. That agreement is also negotiated and submitted to the Department of Buildings, and could be part of the commercial contract itself and the entire transaction. It was codified in 1961. The Department of Buildings is the one that I just mentioned that's really in control of zoning. It issues permits, reviews application, interprets provisions of the zoning resolutions as plural. It issues orders, corrects zoning violations if they come to light, and maintains public records. But they're not the only agency that's involved. It's a welter of agencies in New York that include the Bureau of Standards and Appeals, which handles appeals from a zoning decision by the DOB. It includes the City Planning Department, Commission Development, New York City Development Commission, as well as community boards, the mayor, the borough presidents, and the courts when it goes to litigation. That's a lot of moving parts. I don't see any questions. Next, I mentioned the districts. The first one in zoning, the biggest one, at 75%, I remembered correctly, is the residential. It's the most common one. And there are 10 types of districts, from lowest density, R1, to R10, which has the highest density. And the important thing here in zoning, and it applies to the air rights, is the floor area ratio, FAR. That is the key to everything. And that measures a building's total floor area. And it's a formula, total building area divided by the gross lot area. So you can come up with a figure of 2.0, 3.0, et cetera. The FAR determines how much floor is build a building relative to the size of its lot. It's not always equivalent to the number of stories that can be built, and the FAR can be utilized on a site in a number of different ways. But the important thing to know with FAR is that it varies depending on where the structure is, if it's in a narrow street or a wider street, whether public housing is being contemplated or a public plaza, some kind of open space, whether it's in a commercial as opposed to residential, or whether it's manufacturing. A lot of things come into play here. It's a very complicated area of the law. Again, it's very fascinating. And again, it applies to these commercial real estate, and with respect to due diligence in real estate, zoning has to be considered. And I do zoning as part of my work, but if it becomes a very tricky situation, I will work in conjunction with lawyers who do nothing but this kind of work, specialize in it. Next slide is zoning contextual districts. I bring this up because there's such a thing that covers as an overlay between residential commercial, or among residential commercial and manufacturing, the so-called non-contextual districts, which show a diverse mix of buildings without a predominant context, as opposed to the contextual one, which has additional requirements to make sure there's certain uniformity. And then there's a quality housing program, which is something else that's come into existence in the last, I forgot when the new law came in. I think it was 5 years ago, I'm not sure, to promote alternative height factor in buildings and tower buildings. In other words, to have more housing, and part of it includes affordable housing. That's the program I'm thinking about, the affordable housing program. I think that started about 4 or 5 years ago. In any case, these things all come into play and affect zoning. And again, it's a very complex area of the law, not because you have to be brilliant to do it, but you have to study it and make sure you understand it. All boils down to details. And I'm not trying to lecture here, although I am teaching a class, but all this stuff, the contracts and whatever, everything is detail, information. It's not something, I'm not saying anyone should wing it and sort of go about it with their eyes, whatever, not fully open. Very detail-oriented part of the law, and very interesting as well. Any questions? All right, I've very quick zoning part of this lecture. Now I go into air rights, which I've been talking about since the 60s, and I'm talking about the 1961 zoning resolution. New York City has a system of transferring air rights, which is a way to transfer the so-called unused potential above shorter buildings for development nearby. And again, this was going on before 1961, but it hadn't been codified in the form of the zoning resolution, which really governs everything. There have been subsequent resolutions. I've mentioned plural zoning resolution. There was one in 77 and so forth. Floor to area ratio, it's a critical factor in regulating the heights of new development. That's the FAR formula. And it's the maximum number of square feet that can be built on a site relative to the footage of the lot. And again, this is very important. Now, by the way, with any commercial real estate and due diligence, the zoning lot mergers, which occur as of right on adjacent properties, although that can be sometimes affected if it's a split lot. In other words, there can be a lot in two different zoning districts. That creates a headache and needs to be addressed. But assuming that they're next to each other in the lot is not split, then it occurs as of right. All they have to do is sign this agreement I had mentioned before, the zoning lot development agreement, and it's filed with the DOB, and it should sail through pretty quickly. But there sometimes situations occur where there can be zoning lot mergers to increase air height or to obtain more air rights, increase the height of the structure that wants to go as high as possible by combining more than neighboring adjacent lots. And that is not as of right and involves a lot of negotiation. A lot of it's tricky because what happens in the classic example is some developer wants to put up a tower in the corner of some street, and the other neighbors have smaller buildings, and then it becomes harder to negotiate with all of them because there'll be the one that's the last holdout that will last the most money and wants the most in return for transferring those air rights to that opposite corner new structure that's being contemplated. And it's a difficult thing. I haven't been involved with this, but I know lawyers have explained it to me, to try to arrange that to the benefit of the developer, because if they don't do it well, then they're paying a lot more than they would have otherwise if they don't handle those negotiations well. Transferring air rights, I mentioned that already. It's a zoning lot merger. done through the zoning lot development agreement, the owner of the underbuilt property with unused development rights, because the other thing, air rights are really called development rights, links to property with the developer of a neighboring property. There are special purpose district transfers. That's the West Chelsea, the High Line, the old railroad. If you remember from back in the late 70s and 80s, became now this park, which is beautiful. And they made all these kind of deals to ensure within that district that building can go up without necessarily overwhelming the High Line itself. The same thing in Hudson Yards. It was more complicated because it was built over train yards, and that involved the MTA and New York State trying to come to an agreement. If you ever see a title insurance report on these things, it's incredible because most of these title insurance reports have to mention, even if it's for the purchase of a condo, a quote unquote simple transaction, let's say, or from a sponsor, which tends to be even easier than most other condo purchase and sales, fewer parties involved. These reports go on for pages and pages because some of them give the history in these title insurance reports of what the different things that were involved with the train yards that were underneath and which this whole district was created above it. There's also a landmark transfers preservation commission. I forgot to mention them because that's another agency that's involved with air rights, because sometimes a landmark building can be saved by selling its air rights above it. So that is an injection of capital to help that building, usually a church or something like that, that can still stay there, but they'll sell their rights, and all that is controlled, though. It's not as of right and needs to be approved through a series of applications, sometimes hearings. And if it goes through whatever process, the community board and so forth, and someone objects or they feel it wasn't followed, for example, an environmental impact statement is required in a lot of these deals involving air right transfers, which are not adjacent to one another, then it ends up in court. There's one case I've been involved with recently on the side of people opposing a development in Brooklyn because it's being alleged, and we filed what's called an amicus curiae brief. In other words, we're not the direct parties involved, but we're in support of what the people are trying to do to stop this development in Brooklyn because it's creating a lot of shade and blocking sunlight to areas in this neighborhood. It's actually another interesting case. Okay, environmental due diligence. Now that we moved out of zoning and air rights rather quickly, environmental due diligence, which I mentioned before, it's important to address this issue, especially with commercial property, which can be industrial, a warehouse. It can be also a building that has apartments and or commercial spaces in there, as well as a shopping center, gas station. There are a lot of ways that this comes into play. And the important thing is you can have representations and warranties and even as-is clauses in a contract regarding the environmental situation, but there'll always be a request, and I always do it as a purchaser, and as a seller, I recognize it's necessary to have some kind of due diligence involved, which is really and usually carried out in the contract. It can even be a contingency with time of the essence, of course, so it doesn't drag on, to order and have a phase one report. Now, as a purchaser, I've been involved with that. I was involved with a deal that never went through out in Farmingdale, and it was buying a warehouse property that had some industrial use before. So we ordered the phase one. The phase one I saw, it's a document in this deal that didn't go through, not because of the phase one, there were other issues that arose later on. It's 500 pages. I had no idea what was going on. I mean, I understand that to the extent that as a lawyer, I understand that there were some problems there, and I wasn't sure how bad those problems were, how grave they were, how important they were. So you have to, and what I did at that point was consult part of that team I talked about with the environmental engineer who prepared it. And I got a pretty good idea what was going on, saying that, yes, there had been some issues, but they were under control, and it was not something that would affect the value or the condition of the property itself. And this is part of the due diligence with respect to a commercial real estate deal. It's highly important to get that done. You can have in the contract as is, but you need to have that inspection done for the phase one. If there's ever a problem with respect to the environmental report, and it's usually the lenders are on top of this more than anyone else, as title insurance is not as much, they will ask for phase two. And if it goes to a phase two report, then you know you have a serious issue. There'll be some major oil spills in the past, some horrible contamination or pollution or even radiation. So it's something that needs to be addressed in the due diligence of this. Now, I mentioned the environmental assessment before. There's the environmental impact statement, which is a little different. This is really an assessment, and it has to do with the phase one. As I said, that's the initial report that comes through. If there's a recognized environmental condition, that will usually require, and I just mentioned this before, a phase two investigation, which means you have a pretty serious problem. And that applies. We had this issue in a gas station. The client was buying out on Long Island, underground storage tanks, they were leaking. Buried drums or waste, that's another important problem, with oil staining. All these things are important to have there, because even if there is an as-is clause, and I've seen them again in with respect to environmental, it doesn't cover everything, and it shouldn't. It helps the seller to an extent, but the purchaser better beware and better undertake these kind of reports, and they're not costly. I mean, it's a cost involved. It's not my money, but it's something that I would be committing malpractice as a lawyer if I didn't tell my client to please do this. Otherwise, you could be buying, to quote another phrase, a pig in a poke. It should not be caveat emptor. It should be important to do this, and this is part of the goal of due diligence, especially with commercial properties. Are there any questions? Wow, I keep on sliding from one to one. I don't see any questions. Okay, I've mentioned this before: rent control and rent stabilization. And that was a bigger issue, putting aside what, certainly anything, a lot is really before pandemic, and it applies now, but in a different way. The thing about rent control and rent stabilization was an important thing for anyone buying, investors buying buildings, multifamily buildings up to July 2019. Because what happened before then, what they would do, and I wasn't involved in this kind of work, is try to negotiate to have the rent control, rent stabilized tenants leave. And done legally, of course. There are bad people out there who do the legal things to them, harass them, and even use violence. But legally, what they would do, and I know lawyers who've done this quite successfully, they would negotiate a price, and that would factor into the purchase price by the buyer of the property. And what they would negotiate would be, for example, if there's a rent control, rent stabilized tenant, find out how long they'd been there, how old they were, whether they were married, they had children. A lot of factors come into play that would affect the negotiation and give an idea of how much should be paid to have that person go. Because the whole point of the people buying up until July 2019, when the Housing Stability and Tenant Protection Act was passed, was to then have these people leave to have market rates, which of course leads to another issue about affordable housing in New York, which is why a lot of new construction is, not a lot, but certain construction is obligated to have affordable housing, and a lot of these other developments in certain areas. In any case, the new law in 2019 changed a lot of that. In fact, it dramatically altered the market for those seeking to buy property to convert rent control and rent stabilization to market rate, because it became almost unaffordable to go about doing that. Because this new law affecting about 2.2 million rental units in New York had made it much more difficult for deregulation, for example, through income. In other words, again, this is not the kind of law I was engaged with, but I would talk to somebody and consult a lawyer who specialized in it. But there were ways, for example, of saying if someone's income increased over time, there could be an application to the courts in order to have this person removed from rent control, rent stabilization. This new law put in 2019 caps on rent increases through property improvements. That's diminished a lot more. The percentage went down that was permitted to increase rent. And there was an approval. There's now an approval threshold for conversion that's been increased. There are other issues that came up through here: application fees, security deposit, real estate broker fees, who would pay that, and so forth. The important thing here is that this act before this act, it would have been part of the due diligence for anyone interested in buying a property that had multifamily, in order to determine what the value was and what they needed to do. And this law really dramatically changed everything regarding that kind of investment. Commercial tenant leases, why are we talking about that? Why am I talking about this in a due diligence class? Because if you are buying, or your client's buying, a commercial property that has commercial tenants, there's going to be an issue there that they need to find out what's going on, and how long those leases are, what's being on, and what's being done about them. So commercial leases, there are a lot of types, and I do this myself. aside from the contractual purchase and sales, I do negotiation on leases for both tenants and landlords, but mostly tenants in office context, retail, for banks, warehouse, distributorships, industrial, and automotive. Each one has its own, and those who do commercial leasing brokerage will know about this. Its own little world of different things that apply. And the real estate broker analysis must be, when they try to come up and try to effectuate a sale or get people to agree, what are the entities involved in these leases, the square footage, what consents are needed, the condition of the premises, the term of the lease, what is the occupancy rate in any case of a building which can house a lot of tenants, commercial and residential, escalation clauses, use clauses, all these things are important in negotiating a lease, and then in the analysis of the leases themselves for the purpose of purchasing the commercial property. And in office leases, the important things are, and some of these are common to all kinds of leases, but to look at space itself, what alterations are permitted, what landlord work has been done or has to be done in the future, how the term of the lease ends, what happens then, who's paying for electricity, what kind of insurance coverage is required. All these are negotiable in any lease in any case, and they need to be understood in terms of analyzing the leases. The security deposit, whether there's several or more than 6-7 months, and there's a burn down which permits the part of the security deposit return if the tenant is a responsible tenant, pays rent on time. What's the heating, ventilation, air conditioning, HVAC, any expenses are paid. And the important thing there is the base year when the lease has been negotiated. What is that base year, so that for any lease, what would happen later on and how much can be increased over time. And then the names that can be used and what's the important thing there, whether signage and so forth, or awning, if it's retail or a restaurant. All these things affect the lease themselves and are part of oh my God, sorry about that, are part of the analysis. Now, with retail, it's a little different, and a lot of these things are pretty obvious. What special permits are required. I'm a liquor licensed lawyer, and I always work with one when I have a client that's buying a restaurant business or buying a building in which the restaurant will be located. So we need to make sure that there are appropriate liquor licenses been approved by the state liquor authority. Same thing where they allow sidewalk cafes. What are the rent increases? Is there free rent at all at the beginning of the lease or tacked on at the end? Are the exclusivity clauses that will not permit any competition in that kind of retail in the same block or the same building? What's going on with the sidewalk? Parking, that's more of an issue more in the suburbs with respect to shopping centers and malls. Warehouse and industrial and distributorship leases, they have their own thing. There's usually an engineering report, which is really important to know what the HVAC is what's going with the HVAC and the structures and how the building itself, what kind of shape it's in. The report's very important. Rooftop could be very important. I've had tenants who rented warehouse and they wanted to put on, they were worried about the rooftop conditions, so they could put on some solar panels in order to save money, because what they had going on in the warehouse was refrigeration, and which was costing a lot for in terms of electrical usage. Environmental, important, as well as the zoning is permitted which will allow this kind of structure to exist in that district. Assignment and sublet is another big issue, whether under that lease assignments are as of right, depending on whether it's the same entity that's being assigned to, in other words, more than 50% control, and it's just a change of corporate identity. That's another thing, is whether sublets are allowed. There's a reasonable standard, desk space as opposed to a subtenant. Again, these are all issues in the commercial lease that I would address in any case. That this desk space is more in a office space context or office lease, but there are things that need to be understood by the purchaser and the purchaser's counsel and real estate broker and lender as to the value of the building being purchased that they want to maintain. Is that now? If they want to tear it down and put something else up, it's another kind of analysis. Any questions? Next one is, again, with respect to commercial tenant leases, is the good guy guarantee. That's a big deal now with respect to what the New York City Council passed. Because of the pandemic, commercial lessees, tenants, have good guy guarantees, and now they say, City Council passed, I think in June, that they're not going to be liable personally for failing to have paid rent. That's actually under scrutiny, and a lot of people say it's not constitutional, and no one knows how it'll work out. I haven't seen any cases yet in the courts that have decided on that. But the good guy guarantee is really put there to have personal liability for a tenant to stop paying rent has not vacated the premises. So the example I'm making up now, if they signed a lease that began January 1st, they stopped paying rent in February, or they only paid rent for January and February, but they don't leave the premise till June, and I'm assuming it's my made up example is 1 year. If the tenant doesn't pay, the commercial tenant doesn't pay rent through the May 31st date when they're leaving, the good guy guarantee applied to the person who gave that guarantee. So they'll be personally liable. Once the tenant's out of there, then they'll go after the commercial entity, not the person who signed the good guy guarantee. The problem with good guy guarantees is not so much that they're liable personally, but they have to give notice. And one of the biggest problems is if there's a long period for notice of 6 months, for example, which I think is too long, then if they don't give that notice, it'll be continuing to be accumulating what personally is owed by the person who signed the good guy guarantee, as opposed to the company, or in addition, because if they can't go after the tenant, they're going to go after that person. Another important aspect of leases, insurance, careful review. You have to talk to insurance broker, insurance agent to review that. I give general advice on these insurance clauses, but I always insist that my client, who's a purchaser or a tenant negotiating a lease, consult their insurance broker, and then I talk to that person to say, well, the landlord is requiring too much, or it makes no sense, or it's not applicable, this kind of deal. Other issues in commercial tenant leases include indemnity, access, services, what the landlord is providing, directory, again, that goes to putting where the name goes on, whether in a hallway, or the classic one when they used to have those, I think most older buildings have that. They put the name of the tenant, but if that tenant has a lot of other subtenants, they're not going to have everyone's name down on the board in the lobby. It gets kind of messy. But it's something that needs to be negotiated, as well as the renewal and the options to renew. No questions? And I already go with this. Other types of commercial properties issues. I've referred to some of these: multi-unit, mixed use. The C of O is important. Financial due diligence. Whether tenants, which is the rent roll and the condition of the building. Environmental due diligence. The New York State Industrial Development Agency is an agency which I've worked with in the past when my client wants a break, either on sales taxes, real property taxes, and they're purchasing or obtaining a long-term lease in an area that's considered economically disadvantaged. New York State Industrial Development Agency will support and entertain applications from that tenant/purchaser if they move into that area in order to develop it. And as a result, they'll, on a sliding scale, 10-year scales, most of what they do mostly is say in year 0, the one you start, no real estate taxes or sale taxes. In year 1 of your occupancy, increases slightly. So it's a break that's provided by New York State to encourage development in certain areas. I've done a couple in Mount Vernon and in Central Islip, and they really work to the advantage of the tenant / purchaser. And it's good to have, but it's an entirely different negotiation. It's in addition to the one with the seller and the bank for the loan. Construction development has other types of issues, has others, as I mentioned before: insurance, zoning, FAR, environmental, and hotels, restaurant, which I touched upon only slightly, the C of O, the leases themselves. Someone wants to buy a hotel, and I had a few of those deals a number of years ago. They want to know whether it's a union or it's a flag carrier. They have different requirements and different ideas of how they want to go about with this, but that's part of the due diligence to find out what's going on and what they need to do in order to make the deal work for the purchaser. Next is title insurance. And basically, this is part of the due diligence. The title company, highly important. I'm not just saying that for Marcella's benefit, but I would have no purchase without a title insurance involved. This is another quick overview. There are lender's policies versus owner's policy. The lender will have their own policy if there's a financing involved. And the owner, of course, I'll ask for that on behalf of my client who's buying. And the title insurance basically protects against claims with respect to defect in title and problems affecting ownership, such as mechanics liens. I have a client, it's a litigation matter where a mechanics lien was filed against their property. They were doing construction. They need a refi. Can't be done now because for that refinance, the lender's insisting the mechanics lien is taken out. And that's a big deal because this all occurred during the pandemic. The courts were closed and my client could not go for a refinance. Now they're trying, we filed, there's a process where you file the notice and then what's called an order show cause, an accelerated motion to go to court and say, hey, remove this mechanical lien, it's not reasonable. But until it's done, the lender won't do it because the title company's going to say this has come up and it's got to be addressed. Same thing with tax liens. Title insurance takes care of survey errors rights away. Now, there are three types of coverages. The most common is the standard coverage. There's an extended coverage, and usually lenders ask for endorsements. Those are riders to a contract. Endorsements are riders to the title insurance policy. And there's the famous Eagle policy, which I've rarely used. It's really I've applied it more to co-ops when there is an estate that's selling the co-op. And the important thing there is you never know, it may come to haunt you when you an estate sells a property, especially a co-op, because there could be someone out there who's an heir saying, I was never notified properly, I didn't know about this, and I should have gotten some of the proceeds. That policy will help, because usually you don't have title insurance for co-ops. Other issues that are addressed, or what the title insurance insures, are encumbrances, such as make sure the title is free of liens and encumbrances, deed restrictions, easements, liens from taxes, work performed on the property, condo liens, judgments. Judgments are important because there could be a judgment against the person seeking the refinance or the seller. And depending how big it is, if it's not taken care of, they're not going to remove it or going to want an escrow. And there's a negotiation on that escrow. Is it 2 times, 1.5 times? That depends on the relationship. In other words, 2 times the amount of for example, $20,000 judgment. That has to be removed. Otherwise, the title won't issue something and the lender is not going to be happy. So is title going to ask twice as much of that, $40,000? Not unreasonable, unless you're the person who needs the lien and you don't want to put away $40,000. So sometimes you'll say, take 1.5 times the amount, which would be $35,000. And that's no small thing. It'll make it, or am I doing my math wrong? It'd be 30,000. I don't remember. Anyway, I'm not good at math. The thing is, you hopefully can negotiate that to the benefit of the person who seeks title insurance, the entity, or pay it off. It might be that much easier. Deed restrictions, another thing that's taken care of and addressed by the title insurance. And the title insurance company ensures that they have full use and access to the property. They look at surveys, whether encroachments, adverse possession. Adverse possession rarely comes into play in New York City. The Schedule B to title insurance is really the most important part of the title report, and that's part of the due diligence. There are a lot of lawyers, residential and commercial contacts, who don't read that title insurance company until maybe a week or a day before the closing, or maybe they go to the closing and they never bother to look at it. That's malpractice, because a lot of things come up to there, like the exceptions of title insurance, which are the judgments, the liens, and so forth. And if that's not addressed well in advance of the closing, it's going to delay the closing. And if it delays the closing, it could be detrimental financially to everybody. And if it's the lawyer who does it, that's not good at all. These things must be omitted or cleared at closing, these exceptions. And the purchaser can take subject to exceptions, but that doesn't always work with the lender. And it's something that's really, it involves, and again, it's information, detail, and the other one is preparation. All those things come into play with respect to due diligence in a commercial real estate setting, especially with respect to the title insurance. They have to read, as a lawyer, I have to read that Schedule B. I mean, I have to read the entire report, or most of it, but certainly Schedule B is the most important one. Then at closing, the blessed title insurance people like Marcella, they're saying, let's review the documents. Let's make sure the deed is accurate, the mortgage, because mistakes slip in. It can happen. The last thing you want is something recorded as a mistake with respect to the actual property. The title insurance collects the payoffs, and hopefully that's been addressed by the lawyers, among the lawyers before the closing, that they prepared for it. Make sure any loan is paid off, or there's a CEMA, the combination, in order to lower the mortgage recording tax. So that's pretty much what they say, or what's done. And I think I covered everything. Yes, I really rushed through this. I'm sorry, guys. I hope it was interesting, or certainly informative. And I want to thank Marcella, who's brilliant and really good at what she does, for offering me the opportunity to teach this class today.
Thank you, Fernando. It's always a pleasure to have you. If you guys want to hear more about more of him, he has another class schedule that I'm gonna send the schedule on July 14th on 1031. If you guys already took 1031, there's no point because you won't get credit. But I just wanted to say something for those of you who work with commercial real estate. We are a part of Newmark, Knight Frank now, and most of the brokers at Newmark are using us to get preliminary searches. I'm sorry, and before they pitch their properties to their clients. If there's any clouds on title, we can help figure it out before the property's pitched, and it helps on all the process and increases the chance of not devaluing the property. So if you guys have anything like that and you want any help, please feel free to email me. We are happy to do it complimentary, and of course, we just want to be a part of the deal once it's closed. And that also applies to residential. We can help you with that. Preliminary searches, estimated closing costs. Use us, guys. I'm not here just to give you guys credit for C. Fernando, thank you so much for teaching this class. I think the next time we're going to have to do it like an hour and a half or 2 hours, just so you don't rush and everybody gets their questions answered. I put Fernando's information on the chat. It's on the PowerPoint as well. If you guys have more questions or if you want the PowerPoint, you can either email him or email me. I have the PowerPoint. I can send it to you. And that's it, guys. Thank you so much for being here. It's a pleasure always. And have a great rest of the week and a good summery weekend for you.